Zoe's law is named after the unborn child lost by Brodie Donegan in 2009 when she was hit by a car 8 months into her pregnancy. The law, an amendment to the Crimes Act, seeks to recognise injuries to the fetus separate to the woman's injuries, so the driver could be charged with the death of the fetus. In this community conversation, we explored the broader ramifications of the law's potential passage.
For the first time in Australia, it creates the concept of fetal personhood by defining a fetus as an unborn child to be taken as a living person despite any rule of law to the contrary. So that's sort of pretty heavy language.
Is it about greater criminal penalties in a particular case? Is it about going back and looking at the case of Brodie Donegan and the loss of her fetus and saying, well, should the law in the future apply a greater penalty in that? No. This is all about an ideological battle being fought out in the Crimes Act about defining a fetus as a living person, as an unborn child.
I think it's worth talking about what the proponents of the bill argue, and that is that that her objective to have the injuries to a fetus recognised separately to the injuries to the woman can only be achieved if the fetus has legal status of a person. And that is really the main problem with this bill that many of us see, is that once we do have a bill in New South Wales, or a law in New South Wales, that establishes fetal personhood, then it has implications for other laws and for certainly other circumstances other than grievous bodily harm.
Ending a pregnancy is a devastating act for families. It is emotionally scarring. It has long-term consequences. In my 20 years' experience in this area, it is never undertaken lightly. To turn and say that you are not ending a pregnancy, you are ending the life of an unborn person, I think adds a slant to things, to a decision which is already very difficult for mothers. You know, it is a woman's right to decide these things. Because we should not perform prenatal interventions on fetuses directly against the permission of the women involved, we certainly should not have the right to traverse the body of a pregnant woman by any means, acting as an advocate for the fetus against the best wishes of the women in the family, and to preserve the rights of women to end pregnancies where they feel that it is not in the best interests of themselves, their fetus or their family. I would hate to see anything interfere with those rights.
Because what it says is if a fetus is lost through a medical procedure, through a consent procedure from the woman, well then it's for the woman to prove her innocence and for the woman to prove the defence in this case. And really puts both the woman and the medical practitioners in the dock, proving their case, proving there was consent.
Like any other bill like this, particularly something as complex as this, where there are real concerns raised by people with great expertise in the area, would normally have the examination of at least a parliamentary committee or be referred off to perhaps the Law Reform Commission. Or none of that has happened.
When New South Wales members of Parliament are given a conscious vote, when medical and legal professions at every level take the time not only to write to every parliamentarian but actually go and talk to them in person, one would have to come to the conclusion that a profound change in law is being proposed.
But the same-sex marriage bill in the Upper House, I think there was one vote in it at the end of the day. So, you know, it may be that one MP that you speak to, that one submission you make, could make all the difference in this particular bill.
And I think that, you know, there are 42 members of Parliament. The President won't vote unless it's actually a tied vote. So, you know, we need to be out there convincing 21 of those members of the Upper House why this is bad legislation.